You walk into a grocery store to pick up a few items. You're pushing a cart while looking at the store shelves, and suddenly your feet are off the ground before your back crashes against the hard floor. While there are many aspects of a slip and fall case that you have no control over, there are some important things that you fully control. Unfortunately, far too often, I see people unnecessarily do things that hurt their cases, or worse, destroy their slip and fall cases. If you slip and fall in a store or other business property, avoid making the mistakes that I'm going to discuss. I'm Scott Poisson. I've been helping injured people since 1993. I'm licensed to practice law in Nevada, Arizona, New Mexico, and Florida. Number one, leaving the store or business without completing an incident report. First, claims adjusters are completely suspicious if there's no incident report. They will often deny the claim immediately if there's no incident report because that means, in their minds, there's no record of the incident. An incident report provides timely proof that you fell along with other important details. Importantly, the incident report provides proof that the store is on notice of your incident, which can trigger duties on the part of the store to preserve evidence, including possible video surveillance. Number two, failing to timely seek medical attention. Even if you only have minor aches or pain, go to a healthcare provider. The sooner the better. It is critical that a medical provider document your injuries. The longer the delay, the easier it is for a claims adjuster to defend the claim. Unfortunately, people don't get medical attention quickly for a variety of reasons, and none of them are good reasons. A, they don't think they're hurt bad enough, or they think the pains will go away. No treatment equals no injuries in the eyes of the claims adjuster, which equals no money. B, they don't get checked out because they don't have health insurance or the ability to pay. Don't ever use this excuse to damage your case. We have doctors who will provide the necessary care and treatment immediately on a lien, which means that you don't need health insurance and you don't pay money up front. C, they don't get checked out because they don't want to have to sit in a waiting room. Number three, speaking directly to a claims adjuster. That no matter how nice a claims adjuster sounds on the phone, they are not your friends. An adjuster's entire existence is to try to pay nothing or as little as possible on claims. Adjusters are very good at appearing to be helpful, to entice you to say something that can be used against you later to hurt your case. By talking directly to a claims adjuster, you are playing right into the insurance company's hands. Number four, posting on social media. In today's world, it is standard procedure for insurance companies and defense attorneys to search social media for pictures and posts about you. The context of the pictures and posts can be twisted against you and destroy your case. A picture of you momentarily smiling, laughing, or having fun can be twisted and used to argue that you're really not hurt or you just suffered minor injuries that are no big deal. Number five, lying to your doctors. And this is a big one. It happens too frequently as people think that they can outsmart everyone. Understand that you cannot hide prior accidents, injuries, or insurance claims from an adjuster or defense attorney. A lot of people are less than truthful out of fear that if they disclose something, it could hurt their case. And while it may be true that a fact could decrease the value of your case, lying will outright destroy your case. Here's how it plays out. Person injured in a slip and fall goes to a hospital or doctor. The doctor will take what is called a medical history. They will ask if the person has had prior injuries or complaints to the same parts of the body. The person does not want to disclose back pain that he or she had 3 years earlier from a car accident. The person thinks it will hurt the case if he or she tells the truth. Well, the other side will eventually find out because they get to subpoena all of your prior medical records from hospitals, doctors and insurance companies. They will get your pharmacy records to see if you have ever been prescribed pain medications. They will also have access to national databases that can provide a wealth of information about you. They will use every resource and search under every stone to find out as much as possible about you. And when they find out that you have been less than truthful, they will do everything possible to try to use it to destroy your case by arguing you're a liar. You cannot be trusted and you're not credible. Likewise, they will use this information to make your doctors look bad as well. Here's how they will question your doctor, and bear with me because I know it will take a little bit of time to get through this, but it's important. Doctor, do you take a history from your patients? Answer, yes. Why? It's important to help diagnose and determine what injuries were caused by the accident. Doctor, is it important for a patient to be truthful and provide a complete history? Doctor's response, of course. Do you rely on the patient to be truthful with you? Certainly. And you use this information to help determine your opinions regarding injuries from the accident? Doctor, yes. Doctor, would it be important to know if the patient had prior injuries or problems to the same body part that he or she is claiming came from this accident? Absolutely. What history did the patient give you? No prior problems. If the information that you were provided with is incorrect, could that have an impact on your opinions in this case? Doctor, yes. Doctor, were you aware that the patient was in an accident 2 years ago and complained of back pain? No. Is that something that would have been important to know? Yes. Now this person has a big problem. The person tried to hide information, so now looks like a liar. It also really highlights the prior injury. It's much better to tell your lawyer and doctors the truth. Experienced lawyers are often able to minimize issues that you might think are problems when they know about them in advance. However, when they're surprised, it's too late for the lawyer to strategize how best to deal with a potentially negative fact. I will always remember a case where a client testified in a deposition that he could no longer play baseball after a knee surgery. His testimony was under oath. Unfortunately for him, the defense hired a private investigator who followed him around right to the baseball field and videoed him playing in a very serious adult league. I'm sure you could guess what this did to his case. Number 6, downplaying your injuries. Don't try to be Superman. Fully disclose all aches, pains, and problems to your doctors. If you don't tell them, they're putting it in your medical record, so it is as if you don't have a problem. Often people don't feel it necessary to disclose what they think is a minor pain. The problem is that when the pain hasn't gone away after weeks, or it gets worse, the insurance company can easily argue that it was not from the accident because you never mentioned it to the doctor timely. Here's a tip. Anytime a doctor asks what hurts, start from the top of your head and go to your toes and state anything that is not 100% okay. It's important that you don't exaggerate, and it's equally important that you don't downplay your pains. Number 7, failing to follow doctor recommendations and instructions. Make sure you show up for all appointments. Secondly, follow doctor's advice. If they tell you to do something or not to do something, it's a good idea to listen and obey. If a doctor recommends treatment and you ignore it, you're essentially telling the claims adjuster that you don't need it or you're not hurt that bad. And if the adjuster does not think you're injured, then no money will be coming your way. Number 8, waiting until it's too late. Each state limits the time that you can file suit. And once that time passes, your claim will be forever barred. Remember, you have complete control to avoid every one of these common mistakes if you're injured in a slip and fall. Don't make it easy for an insurance company to hurt your case. I hope you found this to be of value. If so, please click subscribe to my channel, click like, and share with friends and family. And remember, if it's about you, then it is high stakes.